judgment in the matter of X and Y.
Lady Simler will explain the Court's decision.
This appeal concerns the question whether the High Court has jurisdiction to set aside a legally valid order for the adoption of a child other than on an appeal. The unique attribute of an adoption order, in contrast to, say, any other order that may be made for the welfare of a child, is that it is final and permanent. The legal relationship of parenthood between parents and their natural child can only be extinguished by a valid adoption order. And the question is whether the same must be true of the parenthood relationship established by adoption. The appellant, I'll call her AM, is the adoptive mother of X and Y. They were placed for adoption with her in 2012 and then adopted. AM has argued in these proceedings, with the support of X, Y and their birth mother, BM, that in a case where there is no scope for an appeal, there must be some alternative route by which to revoke a valid adoption order in the interests of the child and their welfare. Her case is that the alternative route is provided through exercise of the High Court's inherent jurisdiction, known as parens patriae. The factual background to the appeal is as follows. In February 2023, the local authority issued care proceedings on the basis that X and Y were then beyond parental control. The care proceedings concluded in May 2023 with child arrangement orders that X should live with her birth father and Y should live with BM. An order was also made that X should spend time with BM. Those orders conferred parental responsibility on the respective birth parents. In April 2023, AM made an application in the High Court to revoke the adoption order under the High Court's inherent jurisdiction. The judge accepted that there is a narrow category of case in respect of which the power to revoke a validly made adoption order does exist under the inherent jurisdiction, but said that it couldn't be used solely on grounds relating to the adopted child's welfare. As this was the only ground relied on, she held that she had no power to revoke the adoption order and she refused the application. AM's appeal to the Court of Appeal was dismissed. AM appealed to the Supreme Court, contending that there is a pressing need for a remedy in this case, and inviting the court to exercise its inherent jurisdiction to revoke the adoption order in order to correct the legal fiction where AM is the mother of X and Y, who are trapped in an adoptive identity that they have rejected. The Supreme Court unanimously dismisses this appeal. Lord Stevens and I deliver the judgment, with which Lord Reid, Lord Sales and Lord Doherty agree. The judgment recognises that X and Y are no longer children, and on that basis the parens patriae jurisdiction could not be invoked in this case, even if it were otherwise available. It is nevertheless important to determine this appeal because there are likely to be other cases, like the present one, and the resolution of this question raised does not depend on the particular facts. In arguing that there is an inherent jurisdiction in the High Court to set aside a legally valid adoption order, AM relies on decisions of the Court of Appeal that are said to confirm its availability. However, in all but one of those cases, the Court of Appeal was considering an application to appeal out of time against an adoption order on grounds of natural justice or other serious procedural irregularity or a fundamental mistake of fact. Those decisions, accordingly, provide no support for AM's argument. The first instance decisions relied on by AM reflect a misunderstanding of the Court of Appeal decisions and provide no support for her argument either. Instead, it is necessary to go back to first principles and to consider the nature of the jurisdiction and the context in which it is sought to be invoked in order to determine whether it is available here. The parens patriae jurisdiction is an ancient prerogative jurisdiction belonging to the Crown. To the extent that it survives, it is a residual jurisdiction, and the proper approach to deciding whether it remains available is to consider how it was used historically and how it has continued to be used in modern times. Importantly, a prerogative power will be displaced in circumstances where a corresponding power has been conferred or regulated by statute. Where a matter is regulated by statute, use of the inherent jurisdiction is limited not only when the statute expressly says so, but by implication by the very existence of the statute itself. The inherent jurisdiction cannot be used to circumvent legislation enacted by Parliament, either by achieving the same aim by a different procedural route, or by achieving aims which are incompatible with the legislative scheme. In the context of safeguarding children, the Court's parens patriae jurisdiction has been heavily curtailed by the Children Act 1989. This jurisdiction nevertheless continues to survive, for example, to prevent the abduction of children from this jurisdiction, to protect a child from a forced marriage or from female genital mutilation, or to regulate medical treatment in relation to very ill children or those in need of life-saving treatment where statutory powers are inadequate or not available. Seen in this light, there are fundamental problems with the argument that the inherent jurisdiction must be available to protect the interests of the child in the present context. First, parens patriae powers have never been concerned with the reordering of parental responsibility by extinguishing a birth parent's parental responsibility, however pressing the apparent or perceived need. This is illustrated by the historic institution of wardship, which vested parental responsibility in the court so that significant decisions about a protected orphan couldn't be made without the court's approval, but didn't extinguish or transfer parenthood to new parents. Secondly, where they remain available, parens patriae powers exist to secure a child's protection and safety from serious harm where there is no other adequate mechanism available. Seeking to protect Y and possibly X in this case from Parliament's failure to legislate for a means of revoking a valid adoption order is not a proper basis to exercise this protective jurisdiction. Even if Y or X were in physical, psychological or other danger, this couldn't justify the exercise of this protective jurisdiction in a way that extinguishes parental responsibility by revoking a valid adoption order, given the wide range of statutory powers that are available both to a local authority and to the courts, including under the Children Act 1989, that can protect and safeguard children from harm. Thirdly, the parens patriae powers are only available for a case not adequately covered by statute, but the Adoption and Children Act 2002 has occupied the ground in the present context. Any claim power under the inherent jurisdiction to revoke a valid adoption order would have the impermissible effect of circumventing this detailed and comprehensive statutory scheme. These reasons are sufficient to conclude that the appeal should be dismissed. Our judgment goes on, nevertheless, to conclude that any use of the inherent jurisdiction, if it were available, in order to revoke a valid adoption order as a safety net to protect children in exceptional circumstances, would also cut across the careful statutory scheme created by the Adoption and Children Act 2002. That is because the statutory scheme has always provided that adoption orders are final, permanent, and irrevocable except on one very limited ground, namely legitimation, which rarely, if ever, arises. If the court's prospective assessment that an adoption order is in the child's welfare interests turns out to be wrong and the adoption fails, the court has numerous carefully calibrated powers that exist to protect children. These include making a further adoption order, a power which could have been used in this case. In this respect, the position of an adopted child is no different from that of a child living with birth parents. Put simply, there is no scope for the exercise of the inherent power to revoke a valid adoption order, and it is wrong to approach the question of jurisdiction by saying that if a child's welfare makes it necessary, the jurisdiction must exist. That is to put the case the wrong way round. AM did not advance a case based on the European Convention on Human Rights or the Human Rights Act 1998, and she was right not to do so. The court's duty under Section 6 of the Human Rights Act can only operate within the limits of its jurisdiction. Section 6 does not confer any power on the court, which it does not otherwise possess. In any event, it is difficult to imagine a situation that could ever justify the revocation of a valid adoption order in order to comply with the state's positive obligations under the Convention. Insofar as any reliance was placed on it, there is also nothing in the United Nations Convention on the Rights of the Child that requires a valid adoption order to be capable of revocation. For all these reasons, we dismiss the appeal.
Thank you.